Hello guys, and welcome to another version of this tutorial where I'm going to explain to you what he gave as a scenario. He said a company is located at a residential community. The residents depends on a nearby stream for drinking and domestic purposes. In the course of its operation, the company dump hazardous substances in the stream. As a result, the water become polluted and unsafe for use, thereby depriving the residents of their rights to clean water. The affected resident seeks legal advice on the remedies available under common law. So akwai wani akwai wani company wanda suka yi legal registration sai suka fara operating with the license from the government. Bayan suna operating kuma sai suka fara operating kusa da wani guri wanda wannan ƙauyen suna amfani da wannan ruwan. So su company suka fara dumping wani abu da yake ɓata ruwan mutanen. So that water became contaminated. Sai mutanen suke so a sa company ta daina. Sai mutanen suka same ka yanzu kai as a lawyer ka ba su legal advice. So na farko, you have to look at the legal issues for determination. From the fact, the following legal issue arises under common law. Na farko, whether the act of the company amount to private nuisance. Shin akwai private nuisance a ciki? Or whether the act constitutes public nuisance. Is it public nuisance? Or whether the act of the company is liable in negligence. Shin negligence ne ko kuma za mu musu amfani da Rylands versus Fletcher? Do you understand? So you look at it. Sannan these are the principles. Let me explain to you all. So if you are suing them in action in private nuisance, you have to explain what is the meaning of private nuisance. Private nuisance is an unlawful interference, interfering with the rights, use, and enjoyment of a person's land without his own consent. Unlawful interference with the person's use and enjoyment of land or of someone's right over land. The interference must be substantial. Dole sai ya zama substantial, abin da ya yi tsanani. Substantial, something da ya yi tsanani. Continuous, ya ci gaba, and not trivial. Ba wai abu ne ɗan kaman haka. No, ya yi tsanani kuma ya ci gaba sannan ba ɗan guntun abu bane. It is not necessary that the interference causes physical damage. Ba dole ma sai ya causing physical damage ba fa. As long as it's just continuous, then it is interference. Ko? It is sufficient if it causes serious discomfort or inconvenience. So wannan shine for private nuisance. Abin da yana ka amfani da filinka continuously, maybe wari ko datti ko ƙara ko vibrating ko wani abu. The principle of private nuisance was clearly explained in Bamford versus Thornley, where the court held that an act become a nuisance if it causes material discomfort. Material discomfort shine just internal discomfort to the ordinary occupier of a neighboring land. So kun ga idan aka duba wannan abin da filin yake, wannan abin da company take yi, it causes continuous discomfort to the people. Tunda ba sa iya amfani da filin su. You understand? So if you want to apply this scenario, in the case the residents occupy land close to the company and rely on nearby stream for their daily needs. Like resident ɗin nan suna da fili ne a kusa da wannan company ɗin, sannan kuma company dey dump that wastage in the stream they rely on. The company dump hazardous substances into the stream during operation. Kun ga is bad. The pollution render the water unfit for taking and domestic use. Ba su iya sha. This act directly interfere with the residents' enjoyment of their land. Since access to clean water is essential to normal living, the interference is substantial because it affects basic survival needs. It is unreasonable as unreasonable as no reasonable use of land include poison or sharing water source. The interference is also continuous, not a one-time occurrence. So there is action for nuisance. You can sue them for private nuisance. Advice on private nuisance if you want to. The residents can successfully constitute an action in private nuisance against the company. They may seek the following remedies. They may seek damages for inconvenience, hardship or loss suffer, injunction, and abatement. That's where appropriate to stop the nuisance. Do you understand? They should stop them abatement. So the second thing, you can sue them for action in public nuisance. Apart from private nuisance, you can also sue them for public nuisance, meaning public nuisance occur where an act or omission interfere with the right of the general public or a section of the public, particularly in matter related to public health, safety, or convenience. In Attorney General versus PYA Quarry Limited, public nuisance was defined as an act which materially affects a reasonable comfort and convenience of a class of people. So how do you apply that? The stream is used by a large number of the residents, not just one individual, so it's a public nuisance. Pollution of the stream affects public health and safety. You see public nuisance. The harm extend beyond private convenience to wide community. So it's not just one person that is getting the harm is on. Then the company's action therefore constitute a public nuisance as it affects a section of public collectively. So what do you advise them? Your advice on the public nuisance: the residents may pursue remedy in the following way. They may request the Attorney General to institute proceeding on behalf of the public, or individual residents may sue personally if they can prove special damages such as illness, medical expenses, or financial loss beyond what the general public suffers. Do you understand? So the reason why they say Attorney General, because it is based on the interest of the public, or even you specifically, you can sue for damages for the enforcement, because if you can prove that you have suffered damage over above anybody, then you can sue for that. Then if you want to sue them for action for negligence, negligence means it arises where a person breach a duty of care to another, resulting into damage. To succeed in negligence, the claimant must establish the existence of duty of care, breach of that duty, the damage resulting to breach. This principle was established by Donegal vs. Stevenson, which introduced the neighboring principle application of the scenario. The company owns a duty of care to the residents living nearby who may be affected by its activity. Do you understand? Dumping hazardous substances into the stream used for the drinking is a clear breach of duty. The residents suffer damages including loss of clean water and exposure to heat risk. The damages is feasible, direct, and avoidable. So what they do is they can avoid it, but they continue to do it. Advice on negligence: the resident can institute an action in negligence and claim. They can claim compensation for health hazard. Hazard means health danger and medical expenses. Damages for environmental harm, loss of access to clean water. So they can sue. They can also sue in Rylands versus Fletcher, meaning under the rule of Rylands versus Fletcher, a person who brings into his land dangerous thing for his own purpose is strictly liable if it escapes and causes damage, even without proof of negligence. This rule was reaffirmed in Cambridge Water Co. versus this. So application is right here. The hazardous substances are dangerous thing. What the company brought? The company brought them onto his land for industrial purposes. The substances escape into the stream. The escape causes damage to residents. So all the conditions of strict liability are satisfied. Advice to strict liability: the company will be strictly liable for pollution. The residents do not need to prove negligence. Negligence, only escape and damage. To prove negligence, only escape and damage. So this is it to this regards. Please study this question very well, and don't forget to smash on the subscription button and follow us so that anytime we will post anything, something important, you'll be the first to see. Thank you.